All right, well, let's begin. Thank you, everybody, for joining us this morning. My name's Adam White. I direct the C. Boyden Gray Center for the Study of the Administrative State, and it's my great pleasure to welcome you today for our conference on religion and the administrative state. It's especially a pleasure to welcome you because we tried to welcome you once before in September. We originally scheduled this conference for early September and had to cancel it at the last second due to the oncoming Hurricane Florence. Of course, the irony of a conference on religion and the administrative state being canceled by an act of God was pretty palpable irony. But we're very glad that you could join us today for a day's worth of interesting discussions on interesting new papers. And we're going to begin today with a wide-ranging discussion on the future of religious liberty, centered around a new paper by Professor Mark Mosvesian, who you can see on the screen. Due to some unfortunate recent circumstances, Mark's not able to travel down for the conference. We're very, very glad he could join us today remotely from his office at St. John's. Mark Mosvesian is the Frederick A. Whitney Professor of Contract Law at St. John's University School of Law, where he also directs the law school's Center for Law and Religion. And he co-directs the Tradition Project, a multi-year research initiative exploring the value of tradition for contemporary citizens and the relationship of tradition and change in today's world. He writes on law and religion, contracts, and international and comparative law. Previously, he clerked for Justice David Souter and served in the Justice Department's Office of Legal Counsel. As I mentioned, he's presenting a paper today titled Masterpiece Cake Shop and the Future of Religious Freedom. As with all of our conferences, all of the papers discussed today, which are listed at the back of your program, are available now on our website. I do want to make special mention of one paper in particular. When we rescheduled the conference, one of our authors wasn't able to make this date. We're very sorry to miss him this time. It's actually Professor Mosvesian's colleague at St. John's, Mark DeGirolami. His paper was titled The Sickness unto Death of the Freedom of Speech. I highly, highly recommend it. It is also on the website, so please check it out. But now, please join me in welcoming Professor Mosvesian.
Well, thank you very much, Adam. Thank you for being so accommodating and letting me participate by Skype. And thanks also to the panelists for their understanding. I have some family responsibilities that make it impossible for me to travel right now, and so I'm grateful for everyone's forbearance. So my article, which will appear in the current volume of the Harvard Journal of Law and Public Policy, discusses the court's decision last term in Masterpiece Cake Shop, which is one of several recent cases in which religious believers have sought to avoid the application of public accommodations laws that ban discrimination on the basis of sexual orientation. It's a narrow ruling, and it turns on unique facts, and it does relatively little, in the legal sense, to resolve the conflict between anti-discrimination laws and religious freedom. But Masterpiece Cake Shop is significant because it reflects broad cultural and political trends that will drive that conflict and shape its resolution. I discuss these trends in my article. A deepening religious polarization between the nones, that is, people who claim no religious affiliation, and the traditionally religious. An expanding conception of equality that treats social distinctions, especially religious distinctions, as illegitimate, and a growing administrative state that enforces that conception of equality in all areas of our common life. My article explores those trends and offers three predictions for the future. First, conflicts like Masterpiece Cake Shop will be increasingly difficult to resolve. The law of religious freedom will remain deeply contested, and the judicial confirmation wars will grow even more bitter and partisan than they already are. So it's an uplifting paper. I guess most people at this conference know the case, and so I'll describe it only briefly. A gay couple, Charlie Craig and Dave Collins, asked a Colorado cake designer, Jack Phillips, to create a cake for their wedding. Phillips, a conservative Christian with traditional views about gay marriage, declined, explaining that creating a cake for a gay wedding would violate his religious convictions by making him participate in a relationship he considered unbiblical. The couple filed a complaint with the Colorado Civil Rights Authorities, which ruled that Phillips violated Colorado's public accommodation law in declining to create the cake for the couple, and the Colorado courts affirmed. Phillips then sought review in the U.S. Supreme Court, which ruled that to that the Colorado Civil Rights Commission had violated his free exercise rights, not so much in the decision against him, but rather in its decision-making process. Writing for the court, Justice Kennedy said that the commission had not been a neutral decision maker. In fact, it had shown a clear bias against Phillips, that is, against Phillips's sincere religious beliefs. As evidence, Justice Kennedy adduced certain commissioners' comments, especially one commissioner's remark about the, quote, despicable nature of Phillips's religious convictions. In addition, Justice Kennedy noted that the commission had in prior cases allowed bakers to decline, on the basis of conscience, customers' orders for cakes with messages opposing gay marriage. That disparate treatment suggested that the commission had ruled against Phillips because it was hostile to the substance of his convictions. Because the commission had not shown neutrality with respect to Phillips's religious beliefs, Justice Kennedy concluded, its decision against him violated the free exercise clause. Justice Kennedy deferred to another day the question of what would happen if a state agency did not demonstrate overt bias against a claimant's religion. About the only guidance Justice Kennedy was willing to give was this: courts would have to strike a balance between the right of religious persons to have their beliefs respected and the right of gay persons to obtain goods and services in the market without suffering affronts. Masterpiece Cake Shop thus settles fairly little. The case is nonetheless important for what it reveals about deeper cultural and political trends, all related, that will affect the future course of the law. The first of these trends is religious polarization. Over the past 2 decades, American religion has become polarized between two groups: the nones, who reject organized religion as authoritarian and hypocritical, especially with regard to sexuality, and the traditionally religious, who continue to adhere to organized religion and to traditional religious teachings, especially with respect to sexuality. Each group views the other as threatening and incomprehensible. Neither is going away, and neither seems in a mind to compromise, including in commercial life. This religious polarization figured prominently in Masterpiece Cake Shop, particularly the public's response to Masterpiece Cake Shop and controversies like it. Masterpiece Cake Shop also reflects a second cultural trend, one that Tocqueville saw long ago: an expanding notion of equality. Increasing numbers of Americans endorse a capacious concept of equality, equality as sameness, that treats social distinctions, especially religious distinctions, as arbitrary and unimportant. Asserting the importance of religious boundaries, as Jack Phillips did, seems unreasonable to increasing numbers of our fellow citizens. Asserting such boundaries strikes them, as it did Charlie Craig and Dave Mullins, and at least some of the Colorado commissioners, as deeply insulting, an affront to human dignity. The fact that so many of the actors in Masterpiece Cake Shop did not credit Jack Phillips's assertions of good faith explains much of what happened in the case, and much of what is likely to happen in future cases. Finally, Masterpiece Cake Shop reflects an important political trend: the steady growth of an activist state committed to that idea of equality as sameness. At both the federal and state level, administrative agencies work to promote equality in all areas of life. Their actions increasingly impinge on the traditionally religious, who face an expanding set of rules and policies backed by serious sanctions which promote new understandings of equality, particularly with regard to sex and gender. The actions of the Colorado Civil Rights Commission in Masterpiece Cake Shop offer a good example. Although state officials will likely not demonstrate the same hostility in future cases, the same overt hostility in future cases, they will likely remain committed to the same capacious concept of equality. As a result, conflicts between our anti-discrimination laws on the one hand and the religious beliefs of millions of American citizens on the other will continue. How will the law resolve these conflicts? As I explained in the article, the law regarding religious accommodation is a bit of a patchwork, but the leading test remains the so-called compelling interest test, which holds that government may impose a substantial burden on a person's religious exercise only if the government has a compelling interest in doing so and has chosen the least restrictive means. Notwithstanding Masterpiece Cake Shop's somewhat unusual resolution, the compelling interest test will probably determine the outcome in most future cases. But the compelling interest test presents significant difficulties. The test makes conflicts about religious accommodation judgment calls, the outcomes of which depend, practically speaking, on the intuitions of the people doing the judging. In a polarized society like ours, with deeply divergent understandings about the nature and the value of religion and the scope of equality, intuitions about substantial burden and compelling interest vary widely from person to person and from judge to judge. In a society that can't agree on what's good, how can we agree on what's a compelling interest? The compelling interest test thus makes it hard to predict what result we'll obtain in a particular case and makes the identity of the judges, their backgrounds, and their prior commitments of great importance. In short, the nature of the compelling interest test suggests that the ultimate resolution of the conflict between anti-discrimination norms on the one hand and the religious beliefs of millions of the traditionally religious will remain unclear for a long time to come. In the article, I predict the effect all this will have on the judicial confirmation process. Because the compelling interest test is so dependent on the prior commitments of the judges, the identity of the judges is extremely important. Each side in our polarized society understands how crucial it is to have judges with the right intuitions about religion and equality on the bench. Each, therefore, will fight hard to ensure that such judges are appointed, and conversely, that judges with the wrong intuitions are not appointed. Having judges with the wrong intuitions about religion and equality could lead to negative outcomes in cases about which both sides care deeply. The stakes are too high to be ignored. Well, there's more in the paper, but I'll stop here. I do wish I could participate in the discussion because I'm very interested in what my colleagues and the members of the audience have to say. But that's not really feasible over Skype, and so I'll just look forward to watching the tape later. Meanwhile, I'll close with the following. Once again, a thanks to Adam and to everyone for being so accommodating, and to Leah and Carlos for setting this up. As everyone knows, law and culture have a mutually reinforcing relationship. Court rulings influence the way that our culture perceives social conflicts, which arguments seem legitimate, and which parties deserve our sympathies. But culture, in turn, influences law. And what I've tried to do in this article is explore the cultural and political trends that form the backdrop to our law's attempt to resolve the competing commitments we have to equality and to religious freedom. Those trends, which I argue Masterpiece Cake Shop so clearly reflects, will continue to shape our law for decades to come. Thank you all very much.
Well, thank you very much, Mark, for this paper and this presentation. We wish you could have joined us in person, but we understand, of course, why you couldn't make it. Thanks again for all of your hard work on this, and you've given us a lot to discuss now in our discussion. So thank you very much.
Thank you, Adam.
Okay. Well, as always, the papers for these conferences serve as a useful jumping off point for broader discussions of the topic at hand. And I'm so pleased and honored to be joined by our panelists today and throughout the conference. And I begin by welcoming Richard Katzke. Richard is legal director for Americans United for Separation of Church and State, where he litigates cases under the First Amendment's establishment, free exercise, and free speech clauses. He's a deeply experienced and very highly respected litigator. Before joining Americans United, he was a member of Mayor Brown's Supreme Court and appellate practice. In the U.S. Department of Education, he was deputy director of the program Legal Group, where he developed the department's policy for enforcing federal anti-discrimination laws. He clerked for Judges Stephen Reinhart and Guido Calabresi. Please join me in welcoming Mr. Richard Katzke.
Thanks, Adam. And, good, it's on. Look, I enjoyed Mark's paper very much, and I really appreciate the culture critique. Mark is right, I think, that the struggles between non-discrimination and religious freedom, well, they are struggles, and they'll probably be with us for a while. But I'm not convinced that the battle lines are quite how he draws them, or that the principles at play are precisely the ones that he describes. So that's where I want to start. And particularly, I want to repeat something that is in Mark's paper and that he just said also. I guess I'm pointing at just a screen, huh? He said, over the past 2 decades, American religion has become polarized between 2 groups. The nones, that's N-O-N-E-S, right? Who reject organized religion as authoritarian and hypocritical, especially with respect to sexuality, and the traditionally religious who continue to adhere to organized religion and to traditional religious teachings, especially with respect to sexuality. Each group views the other's values as threatening and incomprehensible. So that's his starting point. I think it's doubly mistaken. First of all, it's mistaken about the nones. Already 23% of the population, they're the fastest growing group in the country, except that they aren't a group. There's the non-religious, who may or may not be non-believers. There are those who describe themselves as deeply spiritual but not religious in a conventional sense. And there are those who are religious, traditionally, conventionally so, but for whatever reason, they don't affiliate with a particular denomination or a particular house of worship. And sure, some nones regard organized religion as authoritarian or hypocritical, to use Mark's terms, but for many, perhaps most, I think that something else is going on. So the Pew Forum reports that nearly 1/3 of all nones identify religion as being either very or at least somewhat important in their daily lives. 78% were raised in a religious tradition as children, though they shed that affiliation later as adults. And of those, only about half cite rejection of or doubts about religious teachings as the reason for their change. Now, as for those with more negative views of organized religion, look, new cases of clergy sex abuse get aired almost daily in many denominations, with bad acts swept under the rug and bad actors protected and allowed to continue. And so sure, there might be some people who think, who are you to tell me about sexual morality? Clean your own house. But I think it's far more common to feel betrayed than indignant. Or just to stay away because, look, you're not sure that your kids are going to be safe there. It's not anger or hostility, sadness, maybe, disappointment, regret, loss. Now, Mark's description of the traditionally religious also struck me as a bit thin. Now, lots of us belong to traditional religions, attend church or synagogue or mosque or temple regularly, practice our faith sincerely, and have it be a meaningful part of our daily lives. But the sexual mores that Mark ascribes to traditional religion just aren't a part of our faiths. Or for some people, they're very much a part of those faiths and are taken seriously, but equally central to the theology is that we don't force others to live in accordance with our beliefs, because that is contrary to the idea of true faith. In Masterpiece and cases like it, scores of amicus briefs have been filed by religious denominations and organizations, Christian, Jewish, Muslim, Hindu, and others, in support of the anti-discrimination laws. In some of those briefs, the denominations and organizations reject the idea that traditional religion and equality norms are in tension, explaining that their denominations affirm the dignity and value of LGBT people in their personal relationships. Others explain that they may actually share Jack Phillips's beliefs, but they also have religious commitments to the fundamental dignity of all people, and so they believe that we have to accommodate diverse beliefs and backgrounds by enforcing non-discrimination principles in the marketplace, even when they're against or and contrary to our own religious commitments. Still others explain that anti-discrimination laws are critical for protecting religious freedom, especially for religious minorities, something that I want to get back to at the end of my thoughts. Now, these denominations are traditional religions. They just have theological commitments that are either different from or prior to Jack Phillips's style of sexual mores, or they believe that when government favors certain beliefs over others, it's bad for religion and contrary to true faith. In short, things are a bit more complicated here than a war between the religious and the anti-religious. To change gears for a moment, I think that Mark is right that expanding notions of equality are a big part of the story here too, but equality is sameness, treating social distinctions as arbitrary and unimportant, as he calls it. Look, saying that law shouldn't afford privileged status to some beliefs isn't saying that social distinctions are arbitrary, and it isn't moral subjectivism either. There's plenty of moral disapprobation on all sides, let's face it. It's not about erasing differences, but about formal equality under law. Cases like Masterpiece Cake Shop aren't about whether Jack Phillips can turn away same-sex couples in the abstract. They're about whether, when there's an anti-discrimination law in place, you get a free pass if your motivation for noncompliance is grounded in religion. That brings me to the structure and logic of the legal arguments. Go like this. I won't be complicit in the sin of marriage of same-sex couples, and out of respect for my religion, the anti-discrimination laws can't be enforced against me. So what if I say, it isn't just weddings. I don't want to be complicit in the sin of, the phrase that's sometimes used, the homosexual lifestyle. So I won't let gay couples make any purchase in my shop or eat a meal in my restaurant. I should be able to refuse service to anyone who lives or acts contrary to my religious beliefs. Same structure of the legal argument there is just the same. Now, in his paper, Mark describes the extension of, here, as he put it, legal equality to racial and other minorities as one of the great achievements of our time. I couldn't agree more. But again, structurally, arguments for race discrimination grounded in religion work just the same way. In Piggy Park in 1968, in the Supreme Court, a restaurant owner argued that Title II of the Civil Rights Act, which is the federal public accommodations law, couldn't be enforced against him because he believed that letting black and white people dine together contravenes the will of God and constitutes an interference with the free exercise of my religion. In Masterpiece Cake Shop, the Solicitor General, the U.S. government, tried to say, don't worry that ruling in favor of the bakery is going to license race discrimination because, and here was the argument, racial bias is a familiar and recurring evil. The same cannot be said for opposition to same-sex marriage, which long has been held and continues to be held in good faith by reasonable and sincere people based on decent and honorable religious or philosophical premises. In other words, race discrimination is bad, so we can ban it, even when it's grounded in religion. Sexual orientation discrimination, not so bad, so it's absolutely protected. Finally, I want to turn to religiously based religious discrimination. That's kind of hard to say. In 2014, a Muslim hotel owner in Santa Monica closes down a pool party when she realizes that the attendees are Jewish. I don't want any effing Jews in the pool. Well, actually, she didn't say effing. That's how the court wrote it in the decision, right? In 2016, a Muslim family goes into a pancake house in Connecticut. The restaurant manager started to look at us up and down with anger, hate, and dirty looks because my wife was wearing a veil as per our religion of Islam. So in front of the family's 12-year-old kid, the manager directs the staff not to serve these people any food. In 2015, the maintenance man in an old folks' home in New Jersey is told by his coworkers that they want to shoot him, and his supervisor fires him because, as a Roman Catholic, says the supervisor, the employee is an outsider who does not fit in. In Minnesota, a health club employs only born-again Christians and won't hire unmarried people living with someone of the opposite sex, or single women working without their father's consent, or married women working without their husband's consent, or non-Christians. Why? Because the gym owners believe that they're forbidden by God, as set forth in the Bible, to work with unbelievers. Finally, I just filed a case in South Carolina. My client, Amy Madonna is her name, she and her kids and her husband tried to volunteer to work with foster children, but they were turned away because they're practicing Catholics. The private foster care placement agency under contract with the state to place foster kids has a strict rule that it won't put kids with Catholics, only with real Christians, they say. No Jews either, by the way. They turn away Jewish families too. Now, if free exercise law licenses religiously motivated denials of service to same-sex couples, then it also sanctions all other religiously motivated denials. You can then be refused employment, thrown out of a hotel, barred from buying a cup of coffee just for being of the wrong religion, and you have no legal recourse. Being troubled by that isn't about a lack of sympathy for the shopkeeper or a lack of respect for religion. The real issue, I think, is this, the real question. Should equal treatment under law be overthrown and religious freedom for all along with it in the name of religious liberty in commerce for some? That's where I think the cultural fault line lies. And with the camps different and the fault line somewhat different, it makes me wonder about the conclusions that Mark draws.
Thank you, Richard.
Thank you.
Thank you. Our next speaker is Professor Vincent Philip Munoz. He's the Tocqueville Associate Professor of Political Science and concurrent Associate Professor of Law at the University of Notre Dame, where he directs the university's Tocqueville Program for Inquiry into Religion and Public Life. He writes widely on constitutional law and political philosophy. He edited a volume of readings on church and state titled Religious Liberty and the American Supreme Court, The Essential Cases and Documents. He won the American Political Science Association's Hubert Morkin Award for his first book titled God and the Founders, Madison, Washington, and Jefferson. Professor Munoz?
Thank you, Adam. It's a pleasure for me to be back here at George Mason with the Boyden Center for the study of the administrative state. I run a program not unsimilar to this myself at Notre Dame, and I know how much work these events are, so thank you, especially to Adam for your work, and as we all really know, thank you to your staff and Leah for all the work.
I thought these events plan themselves.
They've done. The center has become, very, very quickly and impressively sort of the leading place for discussions related to the administrative state. So I commend and congratulate both Adam and George Mason for all the events you do. Thank you to Professor Movesian for an excellent paper. It's so good, I'm just going to spend all my time criticizing it. One comment before I go. I thought Richard's comments were quite interesting, and maybe we can talk about this in the Q&A, all of us. I liked very much like what you said. I'm not sure if this is an exact quote. We don't force others to live according to their beliefs. We don't force beliefs on people. That's sort of central to religious freedom. I think if you look through the Masterpiece Cake Shop, those who know the case, we should ask the question: well, who is forcing whom? Who was coercing whom, right? What did Jack Phillips do to the same-sex couple? In some sense, he wanted to do nothing at all to them. And then what did the Colorado Civil Rights Commission do to Jack Phillips? And where does the coercion really lie? But let me turn to the paper. The paper, I think, addresses one of the most, if not the most important question facing church-state scholars today. What are the underlying causes of conflict between partisans of religious liberty and advocates of LGBT rights? With reference to Masterpiece Cake Shop, the paper discusses three interrelated cultural and political trends. They were summarized very efficiently and very well, I thought. Increasing religious polarization, the emergence of the idea of equality as sameness, and the rise of the activist administrative state. What I want to do is focus my comments on that central claim, that there's an emergence of this new idea of equality of sameness, and that's what's driving, at least in part, the conflict before us. Professor didn't quote what he meant by religion, equality of sameness, so let me quote from his paper. He writes, "The idea that equality means a rejection of the idea of difference per se. All boundaries that distinguish one group of people from another, for example, beliefs and practices that mark out a religious community and exclude non-members, all these differences are presumptively suspect because the implicit judgment they suggest." That's his summary of this new idea of equality of sameness. Under this understanding of equality, the cake maker in Masterpiece Cake Shop was wrong to refuse to design a gay wedding cake because of his implicit negative judgment about same-sex marriage. That negative judgment violates equality of sameness. Okay, I actually don't think this is quite right, or that equality of sameness fully captures what's going on, at least not for all the parties involved. So let me try to explain. If equality of sameness truly was our reigning ideology, then no one could or should express a judgment about anyone else's fundamental beliefs. The cake maker couldn't judge the gay couple, but the gay couple and the Colorado Civil Rights Commission couldn't judge the cake maker. Now, it is plausible that this explains Justice Kennedy's muddled thinking. But it certainly does not explain the thinking of the Colorado Civil Rights Commission, who pressed the case against Jack Phillips. And it certainly does not explain the gay rights movement more generally. They don't hold that no one should judge anyone else. And they certainly don't hold that all moral views are equal or have the same status. Quite the opposite is true. They believe, as most people believe, I'm not singling out this group, almost everyone believes this, that they are right and their opponents are wrong. They subscribe to a comprehensive ideology, as do most people. They believe that they possess the moral truth and that they hold it, and then they hold that it is legitimate for the state to impose it on others. They don't believe in equality and sameness, and that they don't believe that no one should judge the moral views of one another. They believe that individuals like Jack Phillips are morally bankrupt and that they should not possess legitimate social standing. Businesses like those run by Jack Phillips should not be allowed to operate, at least if they discriminate. And people like him need to be converted to a more enlightened way of thinking. That's simply the truth of the matter. This is no different than most people most of the time. It's Tocqueville's thinking about equality that guides the professor's essay. But I don't think Tocqueville, this is somewhat ironic since I'm the Tocqueville professor at Notre Dame, I don't think Tocqueville is really our best guide. If we want to understand what's driving opponents of traditional religious belief, we might consider for our guides Hegel and Herbert Marcuse. I know, that's rough at this hour of the day. Hegel's concept of recognition, especially as it's explained by Charles Taylor. Let me confess, I don't know that I really understand Hegel, but I do think I understand Charles Taylor's explanation of Hegel. The concept of recognition is particularly helpful to understand the idea of dignitary harms. The charge against Jack Phillips was that he assaulted the dignity of the gay couple that wanted him to design their cake. He assaulted their dignity by refusing to recognize the legitimacy of their marriage and the moral propriety of their sexuality. In this new ideology, especially seen on the left, but somewhat to the right, it's the self. It's the identity that we put forth to the world. This is sort of the new deity. Denying the self of others, the self-conceived self that others hold about themselves, is heretical and not to be allowed. It's a violation of equality because equality in this view means having one's identity affirmed by others. To be equal means to be recognized in one's identity, whatever that identity might be. The act of recognition itself is necessary to the realization of equality. If one's identity is not respected or recognized or affirmed, if one is disrespected, to use a term that's sort of gone out of favor, one is denied equal dignity. So not affirming another is a dignitary harm. Okay, that's the Hegelian part, but here's the Marcuse part. But not everyone is actually equal. Dignity requires that one's identity is affirmatively recognized, but not all identities have equal moral worth. To Hegel's concept of recognition, we have to add Marcuse's analysis of repressive tolerance. In advanced industrial societies, Marcuse writes, the realization of tolerance requires intolerance towards prevailing politics, attitudes, and opinions. To achieve a tolerant society, in other words, requires not tolerating the intolerant. Marcuse doesn't mince words. I'm quoting here. Liberating tolerance means intolerance against movements from the right and toleration of movements from the left. He says it requires undemocratic means. What follows is all a quote. It includes the withdrawal of toleration of speech and assembly from groups and movements which promote aggressive policies, armaments, chauvinism, discrimination on the grounds of race and religion, or which oppose the extension of public services, social security, medical care, etc. Moreover, the restoration of freedom of thought may necessitate new and rigid restrictions on teachings and practices in the educational institutions by which their very methods and concepts serve to enclose the mind within the established universe and discourse. The left has taken Marcuse's philosophy of intolerance and just applied it to sexual orientation. So if we want to understand the conflict between religious liberty and gay rights, we have to understand that one side believes that the establishment of equality requires inequality, and that liberty requires oppression. Tocqueville, in his prediction about equality of sameness, can help us understand some aspects of contemporary democratic life, but not, I think, the current battles between partisans of religious liberty and advocates of LGBT rights. The fundamental thing that has to be understood is many, not all, but many advocates of LGBT rights understand the Catholic religion, the Christianity, but especially the Catholic Church, as an oppressive institution, and therefore it needs to be driven out of the public square. Thank you.
Our next speaker today is Garrett Epps. He's professor of law at the University of Baltimore, and he is the Supreme Court correspondent for The Atlantic. He's the author of 2 novels and 5 works of nonfiction, including To an Unknown God, Religious Freedom on Trial, a book-length history of Employment Division versus Smith, which was a finalist for the American Bar Association's Silver Gavel Award in 2002. I'm one of the many people who've been reading Professor Epps for a long time at The Atlantic, and so I'm so glad that he could join us today. Professor Epps.
Thank you, and thanks to everybody who put this conference together. Thank you to Professor Movsesian for a very interesting paper. It's given me a lot of things to think about, indeed so many that I think probably what follows will be completely incoherent, because each time I go through my notes, I realize I want to say something different. But I want to keep my comments as short as I possibly can, given that I am a law professor, simply because I think the discussion and questions from the audience are going to be very interesting. But I do think it's worth examining fairly closely a few key points in Professor Movsesian's paper as carried forward by Professor Munoz. And the one I want to start with is the idea that there is some sort of unprecedented pressure for equality of sameness, an attempt to overwhelm religious boundaries, to oppress religious people, and so forth. And in the paper, it is interestingly enough framed as follows, this paper concerning the facts of Masterpiece Cake Shop. Those who assert traditional religious boundaries, like Jack Phillips, are subject now to some form of censure or pressure for equality of sameness, which is a malign force. But what is interesting in the facts that we know about Masterpiece Cake Shop is that Jack Phillips was not, in fact, asserting any sort of religious boundary. In other words, the demand by Craig and Mullins was not, please alter your worship. It was not, please allow us to become clergy in your denomination. It was not even, please allow us to join your congregation. It was not, change your interpretation of the Bible. It was, please allow us to do business in the market, a market in which you are representing yourself as open for business within the context of the laws. Equality in the market is a concept that I have confronted to a great extent through my long life as a Southerner, because that was the central demand of the Civil Rights Act of 1964. The request that individuals be allowed to do business without regard to certain identity features that others find objectionable is actually a very important part of a democratic civic life. And indeed, I think, and we can explore this later if people are interested, I think that taking that off the table, if we're going to say, no, groups that are traditional or groups that are historically grounded or groups that are majorities are going to have the power to exclude other groups from the marketplace, I think the pressure for sameness and the pressure against pluralism, the pressure against genuine liberty of thought and conscience is diminished, not increased. That to allow people to say, for religious reasons, I am open to the public, but not to you. To allow people to say that for religious reasons or ethical reasons, I am open to the public, but not to people of your race. I am open to the public, but not to people of your sexual orientation. Really raises the stakes of ordinary life to the point that we really begin moving toward a sort of Hobbesian struggle over who's going to be allowed to prevail. Whereas, as people said in the place I grew up, well, I don't have to like them, I just have to serve them. That actually is a very constructive approach toward letting everybody be who they are without forcing anyone to endorse anybody else. The other couple of things I want to say, first of all, is that I think the opposition that is posited between the nuns and the traditionally religious may actually be less cataclysmic than it seems from the outside. For one thing, I don't think the category of nun is a particularly cohesive or novel one. I think that throughout most of American history, there have been a large number of people who would answer a question like that by saying nun. It's a very heterogeneous group. Certainly, I, as someone who grew up, went to religious school, accepted Jesus at the age of 13 at the altar rail, have been involved and written a great deal about religion, both as a journalist and then later as a scholar, spent 10 years of my life studying the Smith case. I can assure you that if the Pew Center on Religion called me on the phone and said, please tell us your religious affiliation, my first words would be none, followed by some descriptions of what it was none of, because I simply do not classify myself in a way that is particularly useful to answer that question. Does this mean that, apparently, I somehow object to religion as authoritarian and stifling? No, where is that coming from? And throughout American history, we've had a large number of Americans who regard religion as an individual matter, who regard religion as a matter of choice, not an institutional matter. And I think Professor Movsesian sees this as a recent trend, religion as choice. But I think the fact is that religion as choice really dates back to and is very profoundly Madisonian. That since 1790, religion as choice, religion as individual decision, religion as independent of institutions has been the core of America's religious culture. That between the framing of the First Amendment in 1790 and the Cane Ridge Revival in 1801, the rise of the Millerites, the rise of the Latter-day Saints, the rise of Jehovah's Witnesses, all the flowering of American denominations that have come from the grassroots up, not from religious structures down, this is really no different than what we're seeing today in terms of people who say, I define my religious identity. It is not done by traditional institutions. It is not done by traditional creeds. And in that context, for that reason, I think it's important not to see the opposition between the traditionally religious and the nuns as being quite so fraught as it may be represented in this paper. For one thing, and this is simply one thing, in my reporting and my dealing with these issues, one of the things that strikes me most poignantly is that some of the most profound attachment, some of the deepest belief in the tenets and the faith and the order of traditional American denominations, whether it's Catholicism or Orthodox Judaism or many Protestant denominations, many of the people most attached to those traditions, in my experience, are themselves lesbians, gay, bisexual, or transgender, who desperately yearn to remain part of those faith communities. And for that reason, and the reason that individuals within religious traditions are heterogeneous generally, I see change over time. I see conflict within the traditionally religious. And I see the possibility that social acceptance will be worked out in a way that is perhaps less dramatic than it seems likely from the paper. Similarly, the survey research that Professor Movsesian cites about nuns indicates that this is actually a highly plastic and fluid category, that maybe half of those who identify as nuns in most of these surveys are people who are just stably secular. It's like, I got my beliefs, I don't believe in this, I don't care. The others are often in transition from one tradition to another, and when they are polled 10 years later, they will turn out to be now adhering to a different religious category than they were when they were originally polled. It's a fluid, both categories are fluid, both sets of belief are fluid. It is entirely possible we will be able to work this out in a way that doesn't simply involve ignorant armies clashing by night. And finally, I want to just throw out the heretical notion, and this is real heresy, that it's possible that in the Masterpiece Cake Shop case, the Supreme Court accidentally got it right. Because what Justice Kennedy says in that opinion is, look, we're not resolving the issues here, but what we're saying is that the parties have a right to a religiously neutral determination of their respective rights. And in this case, he finds evidence in the record, which may be more or less convincing, that it was not neutral. And I think that principle, if we really poke at it, is going to really provide us a way out of some of the mess that we are admittedly in. We are in this mess in part because, as Professor Movsesian quite rightly says, the compelling interest test is a disaster. It's a mess. And I can go into that if people are interested. It simply misstates the facts of virtually every dispute over rights of conscience. It misdescribes them, and it substitutes for what's really going on a kind of arid hypothetical. In fact, what we need to get back to, and what Kennedy in his foggy way is pointing us toward, is the real Madisonian notion. And to me, one of the most moving lost documents of American history is the amendment that Mr. Madison offered in Congress that never got passed and proposed to the states, which said no state shall abridge the equal rights of conscience. Well, this was a part of the Bill of Rights that was going to bind all the states as well as the federal government. And it didn't say the free exercise of religion. It didn't say the establishment. It said the equal rights of conscience. And conscience is an individual thing. Conscience does not belong to those who are in organized religion more than it belongs to nuns. It does not have aggregate power if many people share beliefs versus the person who only believes one thing. And I think if we look at this from the point of view of the equal rights of conscience, we can estimate who is harmed and who is not a little more easily. You know, the question was raised, what did Jack Phillips do to the same-sex couple? Well, I think the answer to that is pretty clear. They brought to him, a sign said, open for business, bakery. They came to him with something that, regardless of how you want to characterize their religious faith, which I've never seen discussed, was important to them as a matter of conscience. We are married. This is the core of our family identity. And we wish to do business with you on that basis. And what Jack Phillips said was, because of my personal beliefs, I must exclude you. You are not worthy to participate in the transaction that I advertised to the public. Now, I hasten to say that I felt torn at the time. I feel sympathy for Mr. Phillips. I'm not even talking about how the case should come out. But I think it has to be seen as a clash of conscience, not as a story of Mr. Phillips and why are people picking on him. If we don't start asking these questions in terms of the conscience, in terms of Madisonian conscience, we're never going to reach the correct result. And I think if we do, there's probably more hope for a good outcome than there may seem to be at this moment.
Thank you. And finally, we're joined by Professor Helen Alvarez. She's professor of law at George Mason University's Antonin Scalia Law School, where she teaches family law, law and religion, and property law. In addition to advising the law school's Civil Rights Law Journal and the Latino and Latina Student Association, she also advises the U.S. Conference on Catholic Bishops, and she consults with the Vatican's Pontifical Council of the Laity and and the permanent observer mission of the Holy See to the United Nations. That's a lot of advice to give out.
Talking all the time. Yeah.
Her most recent book is Putting Children's Interests First in American Family Law, published in 2017. Now, she'll be discussing her own paper this afternoon on our last panel, and we're grateful that she agreed to pull double duty by joining us this morning. Ellen.
Thank you so much. Thank you to the other panelists and to the center for this. Like Garrett, there was so much here to comment on. I'll try and separate it into three kind of categories. I'll start with one that's now I can shorten because it's been well covered, which is the question of polarization. And I do believe there is a lot of fluidity and there is a lot more nuance to speak about the various subcategories within the traditionally religious and the nuns. And one thing I'll add to the mystery of who the nuns are is there's a terrific book out by Frank Newport. He's the head of the polling on religious questions for the Gallup organization. And the book is called God is Alive and Well. And he, in that book, goes through the different methods of polling that were used to ascertain people's religious affiliations and determines that, where you got almost no nuns is when you were being asked in person with a surveyor, and there was a tremendous amount of social pressure to say that you were affiliated with a particular religion, practiced a particular religion. Whereas now, new survey methods really make that far less a matter of pressure. Plus, the current culture does not put pressure on you to say that you are a member of a faith. I mean, someone has pointed out, I don't know if it's true, I think I read it in Politico, that the only mention of religion, for instance, in one of our presidential candidates, Bernie Sanders' platform, is, to end religious bigotry. I was in Scotland recently to give a series of talks, and all over the phone poles in Edinburgh were these signs that said, "Hey, religious bigots." Shut up and take your bigotry home, signed the Government of Scotland and the Church of Scotland, because they have an established church. So the times are quite different regarding people's willingness to say they're nuns, but I too agree that I think there have probably been a fair amount of them. There have been people who are nuns and Unitarians who are suspicious of a lot of different organized religions at different times in history, suing an awful lot through American history. The second point I want to make is on the question of this capacious notion of equality. We're all drawn to it like moths to flame because it's a really interesting question about equality as sameness. And I think this is highly interesting because in the same way as nuns believe that it's nearly impossible to know anything for sure, and doubly impossible that religious authorities might know anything for sure, they do claim to know that some things are indistinguishable from other things for sure. Just as they make other claims about sexual identification, what one sex really is, how sexes are radically different from one another, so that one is one sex but believes to be another, that this is a sure knowledge of the distinctions between the two and what it means to be one and what it means to be the other. There's obviously a lot of incoherence there. I think more what you're seeing is an expression of a compassion, empathy, a desire, why don't we all just get along, for those of us old enough to remember when that was a headline. So I think maybe there's more to it than the question of equality as sameness. I think there's other intuitions and feelings at this very divisive time in politics going on. I also want to have a moment of mourning for the notion of diversity that I always thought had something to do with the differences between people alongside their radical and fundamental equality, and that everybody had something different to bring to the table, which, when joined together, would make something better. More interesting, more beautiful, more complete. You have a 360 view of things. And I think the idea of diversity and what it means, I always liked it, and I think we've lost it from the conversation, especially if the notion of equality sort of takes the field. I have to say that even though this has been more of a conversation than I thought this morning, so I'll just add a little here, that I think it's stunning that that sort of thoughtful administrative or bodies or judges could suggest that distinctions respecting the constitution of sexual pairs are arbitrary and unimportant. This was my sort of shock at the Obergefell opinion that, not only at a time when we're wondering whether our country, one of many among the West, will retain replacement rates of citizens because procreation is sort of, it's competing against so many other values in our economy and our other lifestyle choices. And in a world in which we have never had more evidence than before in the sociological, psychological, law and econ literature about the good of parents and children knowing each other, children being known by the parents who made them and parents taking care of their children, to suggest that the state cannot have thoughts that there is something the state wants to specially value among procreative pairs and who would, again, know and be known by their children. And here's where I would differ very much with Garrett to, I think on the question of the equality in the marketplace is a very attractive concept. On the question of marriage, however, there's two things going on. One, the fundamentalness of it as a social institution and what it means for the well-being of the next generation, who my entire last book was about the state sort of putting children at the back door and adult interests at the front. When you have an opinion that I think Justice Roberts is just dead on about, that is not even it's not a constitutional opinion. It doesn't have a relationship with constitutional law. It's a substantive due process examination that was just made up on the spur of the moment. I think marriage and putting together with that the notion of the difference between discriminating against people based upon their status and being asked to participate in their conduct. I think those two would need to be considered beside the very attractive notion of equality in the marketplace. The other thing, just to throw out, and so two more points, this and another one, is it's fascinating to me that these intermediate institutions that can compete with the power of administrative agencies, the power of judicial decisions, particularly my own church, the Roman Catholic Church, being caught in a sex scandal for the ages, shameful, persistent. I realize that other churches are involved. One of my best friends is head of the lawyer who handles these cases for another denomination, and it's about the same frequency in the denomination that he's handling, but I'm speaking only about my dismay in here with my own, which is most in the news. The fascinatingness for me of the decline of that as a competing institution. Mark talks in his paper of Tocqueville's discussion of these intermediate institutions which would prevent the government from imposing itself so forcefully on the individual. And here's an institution with one of the longest intellectual traditions about sex, marriage, and parenting that has pretty much vaporized its credibility at the moment on these topics. Final thought. And I'm saying is, what to make of this is we need other institutions. We're going to need to build up really at local levels, intermediate institutions that can do this, because this one for the short term, maybe the long term, is giving it away. The final point on the compelling state interest analysis, I could not agree more with Mark's paper that this has become more and more a question of the intuition or the prior commitments of the judges who are doing the analysis. I did, and you'll hear more about this afternoon in my paper, a very, 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 very deep dive on the claimed empirical evidence for the contraception mandate, and it disappears into thin air. There's nothing there. Interestingly, we now are years after that mandate has been imposed, and according to the Centers for Disease Control and the Guttmacher Institute, which has a dog in this fight, and that dog is contraception and abortion, says that women are using slightly less contraception than they were before it was made free. There was no compelling state interest for that mandate. And I did a recent paper on marital status non-discrimination as a category that's actually coming out in the St. John's Law Review, where Mark is. And courts are interpreting that a landlord of necessity give a bedroom to cohabiting couples because it's a compelling state interest, and he points out that they're not saying, I'm sorry, I really can't do that, I disagree with your lifestyle, without any analysis of whether there is, housing in the area, for cohabiting couples, of which there is a great deal, since most people cohabit before marriage and after divorce now in the United States. It's a majority. The idea that this really is a compelling state interest, and the verbiage that's used in these cases, I think, affirms my feeling that Mark is correct about this. This is intuitional. This is a set of prior commitments that judges have, so that now, alongside the, are you now or have you ever been associated with an opinion on Roe versus Wade as a element of judicial confirmations, we're going to have a deep exploration of people's commitments on these other sexual expression issues, whether it's cohabitation, LGBT interests, et cetera. I wish we had a test for compelling state interest that was more like Brown versus Entertainment Merchants, where you actually go and you look at the empirics of the studies of the state's interests. Are they few? Are they countered? Are they causal or correlational? And have a stronger test. So thank you very much.
Well, thank you. Now, I have a couple of questions before we open the floor to audience questions, but before we even get to that, I just wanted to give our speakers a chance. If anything's been said that you want to weigh in on or respond to or anything. Richard?
I'd actually prefer to hear the questions.
Okay. Anybody else? Garrett? Yeah, sure. Well, if I may ask a question before we open it up. Garrett, would you mind just spelling out your point about reorienting the focus of these inquiries towards conscience rather than questions of free exercise? I thought that was very interesting. And
Sure, and by the way, cancel your lunch plans. I think the whole question, and I have thought about the Smith case. I knew all the participants. I spent hours interviewing them, trying to figure out what really went wrong with this horrible case. And very belatedly, long after I published my book, I realized that, in fact, what was going on in the Smith case was not a conflict between the state of Oregon and does it have a compelling interest in forbidding the use of peyote across the board in order to prevent drug abuse and so forth, and the individual consciences of Al Smith and Galen Black, the two counselors who were seeking their unemployment compensation. That's not what really caused the fight, and that's not what it was about. The state of Oregon had no dog in the fight. The state of Oregon had never prosecuted a peyote user, never intended to. It was all this imaginary conflict that really, the genuine conflict in that case that was adjudicated only once, and probably correctly, and then immediately tossed out, was between the employers, which was a private drug and alcohol abuse treatment center that had a certain philosophy of treatment. A philosophy of treatment that, although not explicitly religious, being based on the 12 steps, very much involved in sort of spiritual concepts. And that said, certain kinds of behavior is relapse. We define it as relapse. It threatens the sobriety of the recovering alcoholic or addict. It must not be allowed because it unravels our whole treatment of, our whole theory of treatment. And the two counselors, one of whom, Galen Black, said, I think your philosophy is wrong. I think peyote religion will help, and I am insisting on my right to advocate that to your clients. And then Al Smith, who got dragged in simply because he began to be threatened, you're going to be, unless you disavow your religion, which he had not participated in since he went to work, you're going to be fired. And he finally said, well, I'm not doing that. That was the conflict. It should have been adjudicated that way. Does this organization have a right to its spiritual commitment, and does it have a right to ask its employees not to contravene it? And it got adjudicated in an administrative law hearing in Roseburg, Oregon, perfectly by a local guy who was an ALJ, who said, look, there's two beliefs here. The employer has the complete right to their philosophy of treatment. Therefore, it was misconduct for these two people to engage in peyote religion, and their dismissal was permitted. But on the other hand, they did it out of conscience, so they're entitled to unemployment compensation. Everybody walks away with something. At which point the state of Oregon moves in and says, no, these people are criminals. We want a decision that they are bad. And it went to the Supreme Court twice and produced this hideous decision. And I think if you analyze most of these cases, like Masterpiece Cake Shop, you see two consciences, not one. If you analyze Hobby Lobby, you see two sets of conscience, the Green family's conscience and the conscience rights of the employees who want to make their own decisions, yay or nay, about using contraception. And I think if we can move in that direction of recognizing dueling conscience, we may actually, I'm not sure we're ever going to get to where it's not a judgment call, because that's why they call them judges, but we may actually get, I think, better judges, better dialogue and better judgments. Does that make any sense?
Phil, I see you wanted to weigh in. Let me just throw one more thing into the mix before
Can
you.
I push back on this point, though? I mean,
Yeah, definitely,
it strikes me-
definitely,
I mean,
Well, go ahead,
I'm
please.
sort of blown away by this because, I mean, I like the appeal to Madison, but you say, let's appeal to conscience.
Yeah.
And in all these cases, there are competing claims of conscience. Well, take Masterpiece Cake Shop. We have the baker's conscience, we have the gay couple's conscience, and you say, let's appeal to conscience. And then there's competing conscience. Well, whose conscience is better? And then you say, that will lower the stakes? Seems to me you're elevating the stakes. So who wins on conscience in Masterpiece Cake Shop?
You know, I don't know the answer
And
to
this
that.
is going to clarify
Yeah.
things?
Yeah, first of all, if you ask the right question, even if it's a hard question, it does clarify things. I'm going to stick with that.
Well, take us through
Yeah,
it. What's the
well,
right question and what's the
no,
easy answer?
The right question is, no, there's no easy answer. I never said anything of the sort. I never said it was easy.
What's
I
the
said if you
answer that
ask
the
wrong-
principal
If you
produces?
ask the wrong question, you're going to get the wrong answer. I think the problem with Masterpiece Cake Shop, and the reason why I'm not going to give you an answer, is that I think granting cert in that case, not on that issue, but in that case, was a terrible mistake because the record's such a mess. We don't really know. You can't really say from the record. I covered that case. We can't really say from that record whether Jack Phillips was saying, I don't want to serve you because you're gay, or I don't want to serve you because of a message on the cake. I don't want to sell you any cake, or I don't want to sell you a wedding cake. The record is just a mess. And there were other cases like, I can't remember the name of it, but the photography case that the court, Lane photography, that the court didn't take, in which the record presented the issue much more crisply. And I said at the time, I wrote at the time, and I said just now that I was very torn. I respected Mr. Phillips's concern. I understand his pain. I think what's important is to understand there's pain on the other side. And to some extent, we might want to look at the decision having been made by the people of Colorado, right? This is not something where the Colorado Civil Rights Commission invented a norm of non-discrimination on the basis of sexual orientation. This is a case in which Colorado, in fact, amended one of the oldest public accommodation statutes in the country to include sexual orientation as a forbidden ground of discrimination. I, on the whole, think, as coming from someone from a place where having any sort of public accommodations laws was immensely controversial until well into my teenage years. It was the end of the world if people had to serve other people equally. I think that a state that takes those steps, that decision by the political branches is entitled to some deference. But as for who wins, I'm not, I don't have to tell you who wins if I don't know the record. What I do really think is that we are asking the wrong question. And when we say, does the United States have an interest in the contraceptive mandate? I think that's a really wacky question, and it gets a wacky answer in Hobby Lobby.
On this issue of the competing consciences, this comes up in at least two contexts, right? One is public accommodations law, but there's another one, and given that it's the Center for the Study of the Administrative State, and we care a lot about the structure of government, I find it fascinating that it's coming up more and more in the Hobby Lobby context, where you have, in effect, a federal program that's not, direct payments by the government to the public, but these are programs that are facilitated through the tax code, through employers. This is a half century of largely, I think it's fair to say, conservative or Republican efforts to get government more out of the business of direct payments and direct funding, and to do things through sort of market mechanisms. And it seems to me the great irony of this is that approach to governance in an attempt to limit government is actually will exacerbate the sort of Hobby Lobby conflicts, the Little Sisters of the Poor conflicts, where you have these dueling conscience fights occurring in the employer-employee context or other contexts where social programs have been filtered through the market. And I'm just curious, if anybody has thoughts on this, is there any way to continue those programs without amplifying and exacerbating these conflicts between consciences?
I would jump in just to say that I'm on the board of a variety of charities, and when you look at the amount of government grants and contracts that so many have, and if you list the ways in which, and I think Mark does this a bit in his paper, the federal government can express opinions on these types of things. You have federal grants and contracts. You'll have federal law directly. You'll have the Commerce Clause. You'll have the federal control over the federal workforce. Sometimes the feds can make statements about who the government can contract with privately, et cetera. I don't see this retreating. And even all these moves to privatize various services, right? Big public services even. They are still able to be controlled, not only because of the nature of them, whether it falls under the Commerce Clause, but also because they may still receive government funding, or they may be someone the government is contracting with. The variety of ways in which agencies and the Fed in particular and states can be in control over these types of questions it's just grown so much since, especially the 1980s.
If you attach to participation in government programs, administering a program, receiving government funds, if you attach to that the requirement, you must have this moral view of sexuality, whatever moral view it is, but you say, you must have this moral view, you are going to drive, whoever has power is going to drive one side of civil society out of civil society.
But I don't think that that's what the requirements are, right? The requirements are if you're if you're running a government program, if you're performing a government service, if you're under contract with the government to do something that the government otherwise would be doing itself, then you have to serve everybody the way that the government itself would, which gets to where you started us is it doesn't seem any different in that sense. I gave the example of the case that I just filed about the foster care placement agency in South Carolina. It happens that foster care is done in more and more, and in some states entirely, through private entities that contract with the state and then get federal and state money, and with it come federal and state regulations. And for instance, the state regulations come because the kids are, well, to use the old and now unpopular, disfavored phrase, the kids are wards of the state. The kids are in the care of the state. The state has responsibilities. And if it were doing it itself, it would be following the rules of saying we're going to serve people without regard to a whole bunch of categories of characteristics. And so to say, if you're performing that function for the government, you play by the same rules because it's government work. Yeah,
we don't disagree, though, but that's exactly the point, right? So that's why the Catholic Church does not do adoptions in Massachusetts or in Philadelphia, right? I mean, I agree with you 100%, but the consequence of that is if you have certain views, you can't participate in what government does. And when government does more, it means you drive those views out of the public sphere. I mean, we agree completely.
Let me just point out one thing, which is that one of the most interesting First Amendment decisions of the Roberts Court that hasn't gotten discussed very much because Citizens United sucks up all the air, is a case, and I'm going to muffle the name, but it's Agency for International Development versus some kind of project, in which the Bush administration actually made the claim that Professor Munoz is objecting to. It said that you could not administer certain foreign aid monies, grants, for the government unless you yourself as an organization had a comprehensive policy stating certain views of prostitution, as a problem of human trafficking and so forth. And that if you did not adopt these policies, even if you would administer the grant exactly as written, if you did not adopt these policies, you could not participate in the program. And the Roberts Court said, no, that you cannot do, right? In other words, it is clear that you can't make people say or confess beliefs, or organizations cannot be forced to confess beliefs that they don't believe in. Now, obviously any recipient of government money, just like any participant in the marketplace, can be governed by rules of how they act. But that's not the same thing as telling them that they can't believe it or they must adopt moral beliefs that they don't share. The difference may sometimes be subtle, but often it's not.
Could I add a wrinkle to what Richard said about, the phrase really struck me, things that government would otherwise be doing. And it's just, I think it's a little bit more complicated than that, not only when government, as Philip suggests, sort of enters into an arena with overwhelming force and money, but also when you think about many of the charitable things that, that the government funds now, and we're glad they do, but they were mostly private when they got started. I mean, schools were private, hospitals were private, charities were private, and then the government came into that sphere. So the idea that, the baseline is the government would be doing all of this, and now we've let you into that sphere. I just think it's a little more complicated than that.
But I don't think that that's the point, right? Because you can still be the private charitable agency performing the private charitable service.
Not
and
if
you
they
do it
won't
on your own
license
dime.
you, and sometimes they won't license you.
That's just factually not true.
Yeah, they won't even license you to be.
You can't do adoptions in Boston as a private organization if you don't subscribe to the government's view of sexual morality. That's just a factual statement. And that is the view you're pressing.
Do you want to do it? No. Okay. Conrad, do we have microphones for Q&A? Great. Well, we have microphones in the room, and we have time for questions. Why don't we begin in the back with Renee, and then the next question will be right here.
So this has been a really fascinating conversation. I want to say that Professor Munoz is right about Massachusetts, because I'm from Massachusetts, and he's right. The Catholic Church cannot, is not able to engage in the adoption process. But the question I want to ask is that apparently yesterday, President Trump issued an executive order, which I haven't read, so I admit that, that requires balance in all university and college programs receiving federal funds, intellectual balance, ideological balance. I'm paraphrasing, and as I said, I haven't read it. So, I mean, how does that work? How does the government enforce that kind of mandate or requirement? Is it program by program? What does balance mean? I'm just trying to get my mind around how one enforces balance as opposed to, letting the organizations, do what they do as they've always done.
Clearly, the Center for the Study of the Administrative State has some work to do.
Yeah. I haven't read has anybody read the order? Because it's my understanding that it doesn't use the term balance, that what it says is, that organizations must, public institutions must abide by the First Amendment, which was already the case, and that private institutions must abide by their own stated policies. And which is a kind of a strange demand, right? Like the government says, be yourself or you're in big trouble, right? But the second part of that, and the part that is disturbing, is the idea that it directs the head of each granting body within the government, whether it's the Department of Education or HHS or whatever, to review the policies of the recipient institutions to ensure that they are following their own policies. And that has the potential, not explicitly, but it has the potential to create a kind of censorial bureaucracy. It's like, hi, this is Mr. Guy who signs the checks at HHS. I'm not so sure you're really abiding by the First Amendment. Are you sure you don't want to let this guy speak? It's a little, it's unwieldy and disturbing and sort of, to be uncharitable, it's kind of Trumpian.
It is President Trump's executive order. It would be strange if it weren't Trumpian.
We need some good administrative lawyers to really deal with stuff like this, because a lot of it strikes me as really bad administrative law. Just what does it mean? How does it work? I don't know.
Anybody else?
I know. I think it's lovely to see you again. We were here together last year, and I think it's your questions, like how does this work and what sort of power does it generate, as Professor Epps just are very troubling to me. I'd only say that they remind me of the same oversight that the Colorado Civil Rights Commission, to bring us back to it, was exercising over Jack Phillips' business. It's the same sort of thing. If you look at the remedies, they're like, I mean, it was a moral re-education of Jack Phillips, and that's what Trump's trying to do to the university. I don't like either of them.
I thought you were going to actually draw the comparison to, say, the Obama administration and some of the Dear Colleague letters, the policy
I mean,
on
it's
campus.
all, the federal government running state universities or private universities, I just think is a bad idea. I think, to be honest, I mean, this is far beyond our topic, but you want to see much of the corruption of higher education. I mean, there's a one-to-one correlation with the infusion of federal dollars. Not to say that those federal dollars didn't do wonderful things, especially in the sciences, undoubtedly true, but the more federal involvement, the worse, to my mind.
The thing about that, though, is that the federal regulation is actually quite limited. So there's the federal civil rights laws against race, sex, and disability discrimination, and that's what the Dear Colleague letters came out of, full stop. Otherwise, so I was just involved in the middle of a negotiated rulemaking at the Department of Education as a negotiator on a committee that is about faith-based institutions. And one of the things that I have learned in this process is that pretty much all the stuff that people think of as regulation comes from the private accrediting agencies and not from the government, and that what happens is the directive to and therefore from the accrediting agencies is this peculiar thing that, that Garrett mentioned as a different version of it is whatever your institutional mission is, we're going to see if you live up to that. And that's a peculiar way to regulate, but it also isn't the government. And so I think it's what's interesting to me about the Trump executive order is that it's imposing a whole set of regulations for which the government has been incredibly hands-off of colleges and universities historically and continues to be, except now for this.
Right. Garrett, and then we'll go to our next question.
Well, I think, as you can see, there's a spectrum of belief on many issues on this panel. But I think we are united in the idea that having someone pop up and say, hi there, I'm from the government, and I'm here to enforce the living daylights out of the First Amendment, and you better get with the program or shut the hell up. There's a problem somewhere. I can't put my finger on it, but I think there is.
I mean, I do want to get to the next question, but I mean,
No, you don't.
but I mean, one of the lessons of constitutional liberty over and over again is sometimes it takes affirmative government efforts to preserve liberty. I mean, that's the 14th Amendment. So much of what we talked about today has been government action in service of conceptions of liberty. I haven't seen the executive order. I don't have any big thoughts on it. And I know the neighbors across the street, the Institute for Humane Studies, have already expressed a lot of the same concerns that Garrett raised. But oftentimes, and so much of what we're discussing today is concerted government efforts to expand and preserve notions of liberty that otherwise be interfered with.
But understand we're talking in the free speech context here, which is quite different, distinct legally and also, I think, conceptually in the following sense. One of the interesting developments in 20th century First Amendment law is this idea of censorial expertise or censorial bureaucracy, that one of the key elements of free speech is not that courts don't enforce free speech. It's not that you can't bring an action under the First Amendment when there's state action. It is that we don't have a bureaucracy that controls speech, that it's different to have that kind of bureaucracy about speech than it is, for example, about equality of opportunity. Not to say the second can't be abused, but it is this whole different kind of a category. And the idea that the Trump administration is now going to supervise decisions, that hundreds of decisions that are made every day on campuses about what is free speech, who should be on this panel, who should not, how much time should there be for questions. I don't see any guidance in this order from what I've read about it. I've read a detailed analysis, I haven't read the order. I don't see any guidance of how we resolve that, and it just begins to seem to me like the Ministry of Truth.
Well, if they start picking my panelists, that's when the pitchfork comes out. Thank you for being so patient.
Okay, thank you. So on that note, my question relates to power, and Professor Epps has touched on this a little bit in reference to the proposed freedom of conscience amendment that supposedly began with "no state shall." right? No state shall is a limit on the power of the state.
Right.
It's not a limitation on the power of individuals. And so in light of the way, the background that Professor Epps gave us on Smith, and also in light of the Masterpiece cake shop case, where originally you started out with individual private parties, each with their own perspective, each with the ability to say yes, the ability to say no, the ability to engage, the ability to walk away. When the state steps into the shoes of one of those parties and then places the burden on the other side to defend the bona fides of their belief system, with all the coercion and threat and strength of the state, my question relates to what are your feelings on that balance of power and whether that's even an appropriate position for a government to take in what was originally more of an even playing field. And my challenge to the panel would be to respond without reference to reparations or resolutions for the previous state-sanctioned deprivation of all rights in the form of slavery.
Anybody? Did you have any thoughts?
I'm not sure I really understand the question.
Well, in terms of when you, as you said earlier, you framed it in the issue in terms of competing, claims of conscience.
Yeah.
What happens when the government sort of steps into that dispute between two private individuals and puts the weight and the power of sovereign government on one side of that dispute rather than the other?
But I'm not allowed to talk about slavery, so I'm not sure what.
I didn't say you're not allowed to
I
talk
know,
about
but I'm
slavery,
not understanding how the two things relate. And I think I may fall afoul of this.
Yeah.
Because we are all prisoners of our life experience. And the most overwhelming experience of my life, the formative experience of my life, was living through the 1960s as a young teenager in the segregated South, going to a segregated school, going to a segregated church, in both of which we were taught that God willed the separation of the races, and this was part of our religious belief. And when I was 14, the state stepped in and said, here are categories in the market where you may not actualize those religious beliefs. If you serve food, if you have a hotel that's open to the public, whatever your religious beliefs about, God made the races separate. If you've ever read The Opinion in Loving, you can see the Supreme Court of Virginia says that the laws against miscegenation were laid down by God. It quotes the Bible about how the races are given their own place to live. This is what we believe here in Virginia. This is the foundation of our morality. And the federal government said, without regard to your moral belief, if you engage in certain kinds of transactions in the marketplace, if you rent more than a certain number of units of housing, if you are engaged in business that's open to the public, you will do business with everybody on an equal basis. First of all, this was going to be the end of the world. It was going to shatter. There was, it was the end of, it was equality as sameness. We were going to be living in 1984. Honestly, within about 18 months, everybody was walking around saying, well, what the hell was that all about? People come and they eat lunch and they go home. And the enormous change that was created without, in my judgment, doing a lot of violence to a lot of people. The man who owned Piggy Park was very unhappy, but by and large, people, the market was improved by it, okay? So I don't think I think that when the people, we often talk about how really it shouldn't be judges that make these decisions, the people should make them. And in the Masterpiece Cake Shop case, remember we are starting with a statute, a statute that was passed originally in the 1890s when Colorado said we are not going to have Southern-style segregation in Colorado. And they passed a civil rights and public accommodation statute long before it was passed by the federal government or anywhere else. And then it was amended over time by the political process to add sexual orientation as one of the categories where if you're going to be in the marketplace, you can't refuse to do business on the basis of that. That, I think, is You know, I don't see it as like one person being crushed by the power of the state. I see it, I don't see how we can have a marketplace in a society like ours that doesn't have some rules. And the question becomes, what should the rules be? To some extent, this is subject to negotiation. If you look at various civil rights statutes, you will find things like the Mrs. Murphy law, right? If Mrs. Murphy rents out the carriage house in the back of her house, she doesn't have to observe. If she's renting out a room in her house, she doesn't have to observe the anti-discrimination provisions. On the other hand, if she owns 55 units, right, or if you run a restaurant that's open to the public, you do have to observe. That's all done by negotiation of the boundaries. But I don't think it's that anybody's being crushed by in the marketplace, which is what we're dealing with. You know, the whole other set of questions, which I agree has to be discussed in different terms, has to do with the provision of certain kinds of social services, which are not transactional. But if you're just saying participate in the marketplace and follow the rules, I don't see that as crushing anybody. And I freely admit I may be missing something because I'm a prisoner of my own experience of having been told that this was going to be the end of the world, the end of liberty, we were going to be crushed under the wheel, and it turned out all it ever did, all the Civil Rights Act ever did to the state I grew up in was make people rich because suddenly our economy worked.
We're up against the time, but if you'll
Yeah.
humor just one more question on this, because Gary, you talked about the rules. Justice Scalia's opinion for the court in Smith. You know, we quote some language on the opening page of the brochure where Scalia's defense of this very sort of low bar for the First Amendment was premised on Scalia's notion of democracy and the compromises through the legislative process. And, you know, decades later, in an era where Congress is atrophied, where there's now an entire center to study the administrative state rather than the center to study Congress because Congress doesn't leave us that much to study. You know, the question that, quite frankly, the question that spurred us to begin planning this program a year and a half ago was whether we should think about these issues differently in an era when the rules seem to be made more and more through an administrative process rather than a legislative process. Are those two processes different in ways that really affect the outcomes, to affect the way that things are or are not negotiated? And just to end the panel, I'll be curious if anybody has any thoughts on whether we should think about these things differently in an era when legislation seems to be in decline in general. Helen?
I'm going to just anticipate this afternoon for those who will not be here at the very end of the day. I thought in my paper later, I talk about the combination of political partisanship and claimed scientific expertise. You want to talk about a toxic stew, right? You're very partisan, and you are the owner of the alleged expertise at an agency. And I talk about ways in which this is different from representatives who are supposed to represent a people. I'm not, I mean, you have people who segregate off, you know, someone's the tax guy, someone's the foreign affairs woman, et cetera, who know something very in-depth, but not with the kinds of claims that agencies have combined with partisanship.
My suspicion, and this is just a suspicion, it's not my area of expertise, is you're more likely to get much more rigid and aggressive actions through an administrative process than you are through a legislative process. Right? I mean, there's no way the HHS mandate, as it was produced by the, it's the HHS mandate, you don't get that through Congress. You're only going to get it through the administrative agency making up rules.
Well, I think if there's anything we learned from the past 2 years, it is that administrative law has definitely got the capacity to be oppressive. The only thing worse than that is bad administrative law. And we have seen, you know, and this goes back to the discussion we were having about the free speech order, you know, you shall speak freely order. You know, we are seeing administrative law being done very badly, and I think that the consequences of that is a lot worse than seeing it done well.
So I agree with a lot of that, but I guess that getting back to what your original question was, what do we make of Smith in this context? Is there any, if the requirement is neutral and generally applicable, it's not clear to me that agencies are worse than legislatures in doing, in knowing how to do that. Whether they do it or not is a different matter, right? And that you can hold folks responsible for. But that's a requirement that either you think can be managed or you don't, and I'm not sure that the context makes a heck of a lot of difference for that.
Well, I want to thank everybody. This is such a long panel this morning. I appreciate everybody's patience and engagement, and I also, of course, appreciate our author, in absentia now, and our panelists. So please join me in thanking our panelists.